Thank you. Let me have another wonderful discussion on some of the work that we are doing for our studies. It helps us to reflect and also synthesize the information more, kind of regurgitate it so that it can stick more in our brains, but also so that it can turn out to be informative in terms of helping other people who may be having some challenges or who want to be informed, knowledge, you want to be informed. So I will go through the concept of Ubuntu as a scholarly what in a scholarly context, I would argue, because then I would be able to discuss some of the things and what I am doing. This is something that is taking me almost 9 years now, just in terms of the concept of Ubuntu and the law towards the new constitutional dispensation. So you can imagine how much we have put in, how much time, how much pain, how much tears, how much sweat, how much toil, how much blood, in terms of trying to analyze this issue, the concept of Ubuntu towards the new constitutional dispensation in Uganda. Let me begin by going through. I will refer fundamentally to a few things, but let me start with an opener. So I will tell substantive openers in the context of how I want them to be played out, but particularly each concept or each story that I tell in the context of this opener will have an impact on the discussion that we're having. Story one has to do with the pound of flesh, which is Shakespeare's works in 1600. Shylock holds a lawful bond, 1 pound of flesh, and Venice enforces it. But Portia saves Antonio not through justice but through a technicality. The bond says flesh, but not 1 jot of blood. And what happened is that the law won. How? And justice lost. In the context that the judicial officer then used a hair-splitting technicality and said the jot of blood, whether little, would have an impact in negating, in causing a different requirement as was propounded within the contract of agreement. So if this individual needed a pound of flesh, it had to be strictly interpreted in terms of a pound of flesh. And a pound of flesh meant a pound of flesh. Number two, when I make reference to the oak tree, the case of Nyali Limited versus Attorney General of Kenya, the court declared that you cannot transplant an oak tree from England and expect it to yield the same result in a foreign soil. And I would argue that Uganda's constitution is that oak tree. It is magnificent in design, but not rooted in African moral soil. This is the problem that I intend to diagnose with this analysis of my discourse that I'm presenting. And I emphasize that with the story number 3, which has to do with Macaulay's design that happened in 1835. Lord Macaulay told Parliament to conquer Africa, break the backbone of our nation, our spiritual and cultural heritage, make Africans believe English is greater than their own. He didn't need to have bullets. He only needed law schools. This is the way, and this is why Ubuntu is still absent from Uganda's courts today. And those are my openers in terms of the discussion. By way of introduction, Uganda's 1995 constitution is a document of extraordinary aspiration. Yet 3 decades on, we still have fundamental tensions that persist and unresolved. The constitution speaks a language of individual liberal rights, which is a Western framework. But Uganda society lives or breathes and even resolves its deepest conflicts through Ubuntu communal values. Ubuntu as we know it, I am because we are, is not simply folklore. It is a sophisticated, normative, philosophical, relational personhood. Call it communal dignity or a little bit of restorative justice. In South Africa, for example, Ubuntu has been operationalized as a binding constitutional doctrine by way of the death penalty, which was abolished, but also in terms of property rights that have been reformed, but also in terms of remedies that have been reshaped. In Uganda, it remains a philosophical aspiration. So my discussion will transform this aspiration into an operational, digital, call it legal doctrine in that context. So the tree is there, the roots are missing, and therefore this thesis intends to plant them. By way of literature, I want to argue in terms of 4 scholarly pillars that command this field. The literature would establish certain facts, and I will argue them in terms of 3 facts. Ubuntu is philosophically rich. It is constitutionally operable in South Africa, and its absence in Uganda is produced by colonial design, not incompatibility. That is very important. Part 1, in light of that, in terms of a conceptual foundation, I would argue in terms of Professor Ramosi, who said Ugumuntu, Gumuntu, Gabantu. And Amadume in 1997 argued and said relational ontology in terms of that component of Ubuntu. And Gieche argues in terms of restricted communitarianism, if you look at his works in 1997, which preserve individual agency within constitutional obligation. So this is the formulation adapted in this thesis. Pillar number 2 would encompass comparative jurisprudence. When you look at cases like R versus Mukwanyane, Justice Magkoro uses Ubuntu to abolish the death penalty. When you look at the case of Port Elizabeth municipality versus various occupiers, it argued in terms of restorative justice over proprietary enforcement. Justice Dikolo, I beg your pardon, in the case of Dikolo versus Makata, Ubuntu reshaped defamation remedies, which became a replicable model. Pillar number 3, I would ask someone to help me with a glass of water as I continue, kindly. Some little water, so that I continue. I know that I'll be affected by the dry throat eventually. Pillar number 2, in terms of comparative jurisprudence, S versus Mukwanyane, which is 1995, Magukoro uses Ubuntu to abolish the death penalty, as I just told you. And then when you look at Port Elizabeth municipality versus various occupiers, restorative justice over proprietary enforcement, those are laid in that case. And then when you look at the case of Dikoko versus Moktala, we are saying that Ubuntu reshapes defamation remedies, and that is very important for us to understand. Pillar number 3, I would argue in the context of Uganda's legal scholarship, and what comes to mind in terms of scholarly material is Kabumba in 2014, and then Tumwine Mukubwa in 2008. Their argument in terms of indigenous normative systems structurally excluded Ubuntu that appears implicit in our Ugandan courts, and never doctrinally in that context. And so the oak tree paradox is alive in every judgment in light of that. And then pillar number 4, I would argue in terms of the decolonial thought. We look at people like Wathiongo in 1988 and Kujano in 2000, where they argue in terms of coloniality of knowledge, and then McLaw's 1835 design that crystallized in law books, and then the Marungu, look at Marungu and then Juma and Mutua, who argue in terms of judicial or juridical decolonization that requires epistemic sovereignty. Therefore, Ubuntu is the restoration in terms of this component. Thank you very much for the water. So the gap basically is confirmed the intervention is validated. The field is waiting for this wonderful work. In light of a problem question, I would argue, in light of naming the wound precisely, and this has to be substantively forensic, the problem is not that Uganda lacks a good constitution. No, the problem is that the constitution does not speak the moral language of the Ugandan to the Ugandan people. And that silence was actually engineered. So despite constitutional supremacy, we are saying that Uganda's system marginalizes Ubuntu. There is a lack of coherent jurisprudential framework integrating communal values and producing fragmented constitutional interpretation. And therefore, as a core gap, we are saying that no systematically articulated constitutional doctrine embeds Ubuntu in Uganda's reasoning. It's not by accident, but because positivist colonial architecture was specifically designed to exclude it. Why does that gap exist? That gap exists because colonial legal legacy privileged positivism. Judicial conservatism trained on English precedents led to a complete absence of the doctrine of Ubuntu as the methodology. That is fundamentally very important. And therefore, this thesis responds, it constructs the first systematic Ubuntu constitutional doctrine in Uganda's legal scholarship. So by using Dworkinian interpretative and transformative constitutionalism and delivering a binding, a court-ready interpretative model. So this was McClory's design. It still operationalizes even up to 2025 and 2026. Therefore, this thesis is the counter architecture of that presumption. By way of theoretical framework, I intend to show the theoretical architecture and, in terms of precision, exactly what transpires. I did not choose my theoretical framework by default. I tested 5 major theories against the problem. I built a three-part thesis, or what they call a tripart thesis, or synthesis. A tripart synthesis that is the first of its kind in Uganda's legal scholarism. I argue legal positivism propounded by Hart, explaining the problem but cannot solve. Hart's separation of law and morality is precisely the cage that keeps Ubuntu out by way of Shylock's jurisprudence, as I explained in my opener. When you look at the natural law, talk about people like Aquinas, it aligns with Ubuntu's moral grounding, but not too abstract, too Western, not contextually African. When you look at communitarianism, as propounded by Sandel, this is philosophically aligned, but it lacks the legal adjudicative method. It cannot get Ubuntu into a courtroom. When you look at the interpretivism, the one that propounded by Dworkin, I would adapt this. Why? Because it enables Ubuntu as a constitutional value. It provides adjudicative methods. It reads dignity. It talks about equality. It talks about social justice and Ubuntu bearing provisions. I will also adapt transformative constitutionalism. Why? Because the Constitution as an instrument of social change aligns with Uganda's aspirational order. So by way of synthesis, Ubuntu operates at 3 levels. It operates at level number 1, normative. And by normative, I'm talking about dignity, humanity, and the community. And then number 2, interpretive, in terms of the tools for constitutional reading. And then number 3, doctrinal, in terms of the basis for judgments and remedies. My friends, Ubuntu's absence is not incompatibility. It is a positivist dominance. Interpretivism activates what is already there. And that is the emphasis I'm making in terms of this theoretical framework. Now, in terms of the methodology, I want to justify why this becomes extremely important as a methodology for this thesis. The study is normative and interpretive by design, not empirical, because the gap it addresses is doctrinal and not sociological. My primary method would engage doctrinal legal research, a systematic analysis of Uganda's 1995 constitution by way of the case laws as well, and also the Supreme Court and Constitutional Court in terms of the precedents they set. My secondary method would be comparative constitutional analysis, looking at Uganda's benchmark against countries like South Africa, the most developed Ubuntu jurisdiction globally. And then using the interpretive lens, applying the Dawkinsian interpretiveness, our close reading of constitutional provisions to extract embedded moral principles. Ubuntu is already in the text, the method reveals it. So why is it not empirical? The gap identified is jurisprudential. Community fieldwork is a legitimate future study, but cannot construct constitutional doctrine. Doctrine requires doctrinal methodology. In terms of the data is not neutral. No, all sources interpreted through interpretivism as a method, and Ubuntu in light of a normative content that is deliberate and actually declared not as a weakness. So why no fieldwork? Someone would argue. Because the constitutions are interpreted by courts, not focus groups. The gap is doctrinal, and my method addresses that actual gap. Let me continue. When I'm presenting my findings in the context of this discussion, I have substantively about 4 findings that I want to link, but each finding has to be linked to my opener for purposes of emphasis. And these findings should confirm what these 3 stories I talked about by way of prediction, and how they are troubling, but also how they become more hopeful, and even those stories and what those stories really suggested. In light of finding number 1, Ubuntu is a ghost in Uganda's courts. The Supreme Court and the constitutional decisions of 1995 to the present show Ubuntu values appearing implicitly, but dignity respected, yes, community invoked, yes, but never named, never grounded, never operationalized by doctrine. The courts arrive at Ubuntu outcomes accidentally. So Shylock sometimes not obeyed, but he is never confronted in terms of that. In light of finding number 2, the legal formalism dominates. Hart's rule of recognition governs Uganda's judicial culture. Judges are trained in English positivism, the oak tree methodology that treat communal values as extra-legal sentiments. McClory, educational design, has actually produced exactly what the legal professionals intended. Technically brilliant, culturally estranged. In light of finding number 3, I'll make that proposition in the context of South Africa's model being replicable. When you look at S versus Mukwanyane, Port Elizabeth municipality, look at also the case of Dikolo versus Mokata. Ubuntu doctrinally is deployed, not just invoked. The difference between South Africa and Uganda is not culture, it is jurisprudential. South Africa chose a transformative constitutionalism. Uganda too can actually choose it. And in light of finding number 4, the thesis delivers the solution. A 3-level Ubuntu interpretive model. By way of normative, we are arguing that Ubuntu is a constitutional value. By way of interpretative, the weekend moral reading activates it. And then number 3, doctrinal concrete framework for Ubuntu grounded judgments. Portia's wisdom now becomes codified. A pound of flesh is sometimes not demanded, but Shylock is never confronted. This thesis confronts Shylock. By way of substantive conclusion in the context of this discussion, the thesis sets out to prove one thing, and it does prove that. Ubuntu is normatively compatible with constitutionalism. It is not a threat to constitutional order. It is a constitutionalism at its fullest African expression. Its absence from Uganda's jurisprudence is not neutral. It is the continuing legacy of Lord McLeod's deliberate erasure and Hart's positive sketch. It is designed and it can be undone. The 1995 Constitution already contains Ubuntu seeds by way of dignity, by way of equality, by way of social justice, by way of national unity. The tree is there, but the roots were cut, and this thesis replants them. The argument also, by way of another conclusion, would be that no constitutional amendment is actually required. Dworkinian interpretative activates Ubuntu within the existing constitutional text. So only the courage to read the constitution with an African eye is needed. A new constitutional dispensation should be grounded in Ubuntu both as necessary but also as achievable. So from Shakespeare's courtroom to McLaury's parliament to the courts of East Africa, the same truth echoes. Law divorced from moral culture of its people is not justice. It is conquest by other means. Uganda deserves better, and this thesis offers that particular solution. By way of recommendations, I would argue the recommendations do not require reinventing the Constitution. They require reading it honestly. The first would be to the judiciary. Adapt value-based Dworkinian adjudication. Treat Ubuntu grounded in dignity, in communal harmony, and restorative justice as binding constitutional values, not obiter. Portia read the bound with wisdom. Uganda judges must read the Constitution with an African eye. Portia, the story I told you, read the bond with wisdom, but we are saying you judges of Uganda must interpret the Constitution with African eyes. And to the academia, we ought to develop Ubuntu jurisprudence as a formal legal discipline, revising McLaury's design as its source. The legal profession who cannot speak the moral language of their people is an oak tree in a foreign soil. Ubuntu must become compulsory jurisprudence at every Ugandan law school, beginning with Makerere and the others. So to Parliament and also the policymakers, we are saying institutionalize Ubuntu as an express constitutional interpretative principle through constitutional amendment or a judicial interpretative act. The oak tree has survived long enough in the foreign soil. It is time to plant it in Uganda's own moral earth. Ubuntu is already there. The dispensation is waiting. By way of substantive limitations, I would argue that my limitations are acknowledged honestly, but I will submit fundamentally the following. Limitation number one, the doctrinal focus is limited by way of empirical engagement with community-lived Ubuntu experience. No field interviews or even sociological data, although I mitigated this by comprehensive comparative jurisprudence of South Africa and strong Dworkinian theoretical grounding. So the gap is doctrinal. The method addresses the actual gap. Limitation number two would be in terms of the sparse Ubuntu case law in Uganda. There are few explicit Ubuntu-based Ugandan court decisions to analyze, and I mitigate this by using the interpretative method that covers implicit Ubuntu reasoning beneath formal judicial language. The scarcity of explicit decisions is the finding. It proves the gap. Limitation number three would be in terms of the philosophical interpretation. Potential subjectivity in applying Ubuntu as a legal standard. Ubuntu is a living, a contested concept mitigated by Gueche's restricted communitarism that proves to be precise, bounded by formulation, and the framework is disciplined and not impressionistic in a way. Therefore, these limitations reflect the very gap that my thesis tries to identify, and they are inherent to this pioneering work. So every first study in a new field carries those marks that I just talked about. In terms of further research, if you like, the thesis is a beginning and not a final. It's a terminus, if you like. It's not a terminus, it's not the final. These horizons are actually opened by this work. Number one, Ubuntu in private law, for example. This thesis basically focuses mostly on public constitutional law. So a neutral extension is Ubuntu penetration into private law in terms of family law powers, in terms of contract, in terms of property, in terms of succession. While communal values are already, culturally operative but legally invisible, how would you engage, for example, in terms of this contractual obligation or inherent frameworks in terms of Uganda? Those are components that you would think about. And also another area for further research would be the Pan-African or the Pan-East African comparative study. The thesis compares Uganda with South Africa alone, and as a comparative study, perhaps across Kenya, Tanzania, Rwanda, could also reveal whether Ubuntu jurisprudence is uniquely a South African or a broader African constitutional resource available to all post-colonial states, for example. And then another in terms of a further area for research would be the empirical grounding. A future research should actually integrate community-level interviews, judicial surveys, for example, and even litigant perceptions. So to test whether Ubuntu constitutionalism is actually desired and understood by ordinary Ugandans. In terms of lived experience, we have to do that, but it must eventually validate the doctrinal aspirations. So we are saying that each limitation identified is an invitation to the next scholar. The project of Ubuntu constitutionalism is therefore generational in that context. So it's very, very important for us to understand that in light of the discussion. By way of my closing statement, I would argue and say that from Shakespeare's Venetian courtroom, which I explained at the beginning, where justice was actually satisfied by but humanity was actually betrayed, to Maclaury's Parliament issue. Remember the argument of Lord Maclaury, where the deliberate erasure of African legal wisdom was actually announced as a policy, to the courts of East Africa, where the oak tree still struggles with foreign soil. The same wound has actually been visible for centuries. And therefore, this thesis does not merely describe that wound, it constructs the remedy. Ubuntu is not incompatible with constitutionalism, it is a constitutionalism fullest African expression, and that it is already in the constitution awaiting to be read with African eyes. So a new constitutional dispensation is both necessary and achievable. The dispensation is waiting, and I'm honored to have been one of those to open this door. I thank you.